In this short video, we're going to talk about prior written notice. This video is part of a series intended to explain portions of Alabama's procedural safeguards special education rights. This video is not intended to replace reading the entire procedural safeguards document. Prior written notice is a requirement included in the Individuals with Disabilities Education Act, or IDEA. Prior written notice refers to the requirement for the school to provide notice in writing to the parent to document the actions being proposed or refused throughout the special education process, and provide the parent an opportunity to consider what the school is proposing or refusing and decide to agree or object to the decision. More specifically, prior written notice must be provided to the parent when the school proposes or refuses to initiate or change the identification and evaluation, the educational placement of the student, or the provision of a free appropriate public education, or FAPE. The requirements for prior written notice are documented on the Notice of Proposal or Refusal to Take Action form. 7 required elements must be included in the prior written notice documented on the Notice of Proposal or Refusal to Take Action form. The prior written notice must describe the action that the public agency proposes or refuses to take. Explain why the public agency is proposing or refusing to take the action. Detail each evaluation procedure, assessment, record, or report the public agency used in deciding to propose or refuse the action. Include a statement indicating the parent has protections under the procedural safeguards notice in IDEA, and if the notice is not for an initial referral for evaluation, how a copy of Alabama's procedural safeguards special education rights can be obtained. Provide resources to contact for help in understanding IDEA. Describe any other options the Individualized Education Program (IEP) team considered and the reasons why those options were rejected. And provide a description of other reasons why the public agency proposed or refused the action. The prior written notice must be written in clear language that the general public can understand and in the parent's native language or the appropriate mode of communication. If the parent's native language is not English, the school must provide the prior written notice in the parent's native language, unless it is clearly not possible. If the parent's way of communication is not written language, the school must interpret the prior written notice orally or in another mode of communication. For example, American Sign Language. Thanks for watching. This video is part of a series explaining portions of what is included in Alabama's procedural safeguards special education rights. This video is not intended to replace reading Alabama's procedural safeguards special education rights. For more information about Alabama's procedural safeguards special education rights, visit alabamaachieves.org and search procedural safeguards.